President, I seem to be getting some, please. Just hold 1 minute more.
Okay, sure.
Good afternoon, all. President.
Yes, good afternoon, everyone. Good afternoon. Sorry for the delay. We were having a little difficulty with Justice Barrow's connection. Madam Deputy Registrar, you may commence proceedings.
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, St. Lucia, judgment delivery in CCJ Appeal LCCR number 1 of 2024 between Marius Wilson and the King. The members of the delivery panel are Mr. Justice Saunders, President and Presiding Judge.
Good afternoon, everyone.
Madam Justice Raj Norsley.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon to all, and sorry for the delay.
Mr. Justice Burgess.
Good afternoon, Counsel.
And Mr. Justice Jamadar.
Good afternoon to everybody.
May we have the appearances, please? Thank you.
May it please, Your Honors. My name is Alberton Rushlow. I appear along with Ms. Alberta Rushlow on behalf of the appellant.
Yes, good afternoon again, Mr. Richard.
Good afternoon. Good afternoon, everyone.
Good afternoon, Your Honors. Should it please this Honorable Court, I, Kelly Thompson, respectfully appear on behalf of the respondent in this matter.
Yes, good afternoon again, Ms. Thompson. The judgment of the court in this matter was a unanimous judgment. It was authored, the lead opinion or the opinion of the court was authored by Mr. Justice Barrow, and I will invite him to read this summary.
Thank you, President. As is usual, to be reminded, this is merely a summary and is not intended to be used in any way as a substitute for the substantive judgment. Here is the summary. On 7 June 2012, Winsbert Alexander was at Spinner's nightclub in the company of several relatives, including his niece, Lone Alexander, and his girlfriend, Rita DeMar. Marius Wilson, the appellant, who had been cohabiting with Lone Alexander, arrived at Spinner's in the early morning. The appellant testified that there had been several incidents between himself and Winsbert in which Winsbert had threatened to kill him. Shortly after entering Spinners, the appellant said that a man known to him shouted, "Watch out, make a 180-degree, fire!" A nickname for Winsbert was Fire. The appellant said that when he turned around, he saw Winsbert charging towards him, his hands outstretched, holding an object with a black handle and silver body, which appeared to be a firearm. The appellant drew his licensed firearm and shot Winsbert. He said he told the police, who asked him if he had shot Winsbert, he had not done anything wrong. The guy was the one who attacked me with a gun, so I defended myself. There was no other firearm found at the scene. The appellant was charged with the offences of intentionally causing dangerous harm to Winsbert Alexander and using a deadly instrument with intent to cause grievous harm to Winsbert Alexander, contrary to sections 99(1) and 1011B of the Criminal Code of St. Lucia, respectively. The lone eyewitness who gave evidence that supported the prosecution, Rita DeMar, said that Winsbert was not doing anything before he was shot and that it was the appellant who shot Winsbert. All other eyewitnesses, including Winsbert, who had previously given full statements to the police, stated they could not recall the contents of their previous statements. The trial judge granted the application to treat these other witnesses as hostile witnesses, allowing them to be cross-examined by the prosecution. On 30th July 2021, the appellant was convicted of both offences after a jury trial. On 8 November 2021, he was sentenced to 5 years on the first count and 4 years on the second count, both sentences to run concurrently. By judgment dated 25th July 2023, the Court of Appeal dismissed his appeal against conviction and allowed the appeal against sentence, varying the sentences of 5 years and 4 years to 3 years and 2 years respectively to run concurrently. The appellant appealed to the Caribbean Court of Justice, citing 6 grounds of appeal. These grounds mainly asserted that the Court of Appeal was wrong in law when A, it upheld the trial judge's dismissal of the no-case submission made at the trial. B, it did not agree with the submission that the trial judge had misdirected the jury on the evidential nature of hostile witnesses. C, it approved the trial judge's direction to the jury on the issue of good character given the appellant's profile. And D, it disregarded the written submissions that the defense of self-defense, which was advanced at trial, was not negatived by the prosecution. Thus, the appellant claimed he suffered a miscarriage of justice. The judgment of the CCJ first considered the appellant's submission that the trial judge's direction would have caused the jury to use the, quote, evidence of Winsbert to bolster the evidence of Rita DeMar, thus resulting in a flawed conviction. The CCJ found that the judge confused the reference to whose evidence the jury was being asked to decide was true or untrue. At the material point in the direction to the jury, the judge was addressing the evidence of the appellant, not of Winsbert. The impugned statement of the trial judge was quote, "The evidence of this bad blood does not mean that Winsbert's evidence is untrue or that Winsbert attacked the defendant," end of quote. However, given the directions which immediately followed this misstatement, the court found that what the judge intended to say, as captured in the print in square brackets and italics, was, quote, "The evidence of this bad blood does not mean that," underlined, "the defendant's evidence is untrue or that Winsbert attacked the defendant." Furthermore, the CCJ held that the impugned statement could not have misled the jury, as the appellant's submission itself recognized that nothing said by Winsbert could be taken as, quote, "evidence," and none of the hostile witnesses said anything which, if taken as evidence, prejudiced the appellant. Further, the trial judge repeatedly directed the jury that what the witness did not accept as their evidence was not evidence to be considered in the case. This ensured that the jury was clear that any suggestion of what occurred as put by the prosecutor to the witnesses as facts stated in their police statement was not evidence and was not to be treated as the testimony of the witnesses. While the appellant acknowledged that the trial judge gave a full direction on good character, it was submitted by the appellant that the trial judge's direction on good character was too broad in telling the jury they could take account of, emphasis, everything they had heard about the appellant. This, it was said, opened the floodgates to irrelevant, inadmissible, and prejudicial matters to be considered given the appellant's profile in a small society like St. Lucia, where everyone knows everyone. The CCJ held that the submission did not withstand scrutiny, given the tenor of the directions from which the targeted phrase was extracted, together with the earlier limitations given to the jury when they were impaneled, which cautioned them to confine their considerations to what took place in court. The appellant also submitted that the trial judge failed to put the appellant's defense to the jury, fairly to the jury, in that the trial judge should have directed the jury that, having regard to Rita DeMar's evidence, they must consider whether the evidence was sufficient to negative the appellant's claim of self-defense. The CCJ disagreed, holding that there was sufficient evidence to negative the claim of self-defense, and it made no difference whether that claim had been negatived specifically by Rita DeMar's evidence. Additionally, as regards the no-case submission, the CCJ held that the appellant failed to show that the Court of Appeal should have held that the stated evidence, including the absence of the alleged firearm wielded by Winsbert, together with the uncontroversial fact that the appellant shot Winsbert, was not sufficient to establish a case of unlawful shooting for the jury's consideration. That is the summary. Thank you.
Thank you very much, Mr. Justice Barrow. That's the judgment of the court. Is there anything from counsel? You're on mute, Mr. Richard.
No, Your Honors.
Yes.
Nothing from me.
Nothing from the respondent, Your Honors.
Okay, thank you. Well, that concludes our proceedings today, and I would ask the Deputy Registrar to close the proceedings.
Thank you, President Saunders. Thank you, Madam Justice Rajnath-Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Jamada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.